Hello and welcome to the 2023 Sexual Assault Awareness Month webinar series. Our second webinar of the four-part series is Solving Violent Crime Through Lawfully Owed DNA, Outcomes of Efforts to Address Missed DNA Samples. Our presenters today are Dr. Rachel Lavelle, Assistant Professor of Criminology and Director of the Criminology Research Center at Cleveland State University, and Shannon Musson, Assistant Prosecuting Attorney in the Cuyahoga County's Prosecutor's Office, specializing in the Gold Cold Case Unit. Without further delay, here's their presentation.
Hi, welcome to our presentation today. Thank you for joining. We're going to be talking about how violent crime is solved through lawfully owed DNA and what we've done in Cuyahoga County to address the issue of missed DNA samples over the past approximately 6 years. My name is Dr. Rachel Lavelle. I'm an assistant professor of criminology, and I'm a director of the Criminology Research Center at Cleveland State University.
And I'm Shannon Musson. I'm an assistant prosecuting attorney in the Cuyahoga County Prosecutor's Office, specializing in the Gold Cold Case Unit.
Want to give a funding acknowledgement that this research and activities have been supported by two Sexual Assault Kit Initiative grants, one in 16 and one in 19.
We'd like to start our presentation today by highlighting some of our high-profile misses. And the first one we have to talk about is Anthony Sowell. That name is probably familiar to some of you out there. This circumstance did get national media attention. So Anthony Sowell is a serial rapist. He, in fact, raped someone in 1989, wherein he received a 15-year prison term. During that time, he was swabbed. His buccal cheek swab was collected. However, it was not sent to the lab, or it was lost, or it wasn't suitable for entry. We don't know exactly why it didn't make it into CODIS. But we know that in 2009, Cleveland police found decomposing bodies of 11 women in and around his house. So there was national outcry about this. The medical examiner's office went out, we collected evidence, and Anthony Sowell was arrested in October of 2009. He was swabbed. He hit to these previous sexual assault kits, one which resulted in the death of one of the women. The case went through the process for about 2 years, lots of motion practice, lots of pre-trials, once again, lots of media attention following this. And ultimately, Anthony Sowell did receive a life sentence in this case. He was found guilty by a jury. He, in fact, had a trial. The trial lasted about a month long. And ultimately, he was sentenced to life in prison in July of 2011. He went through the appeal process, but ultimately, the appeal process is quite lengthy. In 2020, everything was affirmed, and his sentence was left to stand. If you followed Sowell, you would now know that he did pass away in February of 21 due to a terminal illness. Nevertheless, that's the background on him. And this was a big miss, 11 women who, are deceased when he could have been collected and submitted to the lab sometime before that. So that's tragic. A second high-profile miss, not necessarily the same caliber, but still, long-lasting effects for survivors who were victims of sexual assaults. Larry McGowan is an offender who missed being swabbed for his DNA for over 15 years. You'll see on the slide that he was in and out of our criminal justice system for 15 years for other kinds of crimes: felonious assault, arson, theft, burglary, robbery, motor vehicle theft. He was also the suspect in a murder. He wasn't swabbed upon arrest in all of these circumstances. It wasn't until 2012, after being released for another case, 2 weeks later, he assaulted a woman in Akron, and he was swabbed. And when his swab was entered into CODIS, he linked to 6 sexual assault cases, which had already been linked in the CODIS system forensically based on the evidence. So ultimately, Larry McGowan was sentenced for raping 6 women and killing 1 to a 25 years to life term of incarceration.
The issues around Anthony Sowell brought about a lot of issues and media press about why his DNA was not in CODIS, even though he had been in prison and served a 15-year sentence for prison. He should have been in there. So there was some investigative reporting and work with the Ohio Department of Rehabilitation and Corrections around 2010, 2011, around issues of collecting missed swabs, specifically within the prison system, to see, for example, why Anthony Sowell and why later on Larry McGowan had not been swabbed in prison. Here are some of the problems that they identified as reasons for these misses. One was that the prison swabs were put into the prison mailroom and were staffed by inmates, and many of those samples never made it to the lab. This usually gets a little bit of a laugh when we present in person. It's kind of funny, but kind of not funny, in the sense of like, that seems like an easy sort of fix that you don't really want to put them in the mail to put them in that's staffed by inmates and not being able to do that. So instead they started sending them through certified mail. Prior to the work being done that I'm talking about here, there was really no way for the individuals who worked for the prison system to know whether someone was in CODIS or not. So they had to ask them if they'd been swabbed upon entry. And so you can guess that many offenders didn't say that. They were like, oh no, I was already swabbed, it's fine. But there was really no way for prison workers to be able to see whether someone was actually in CODIS upon exit from the prison system. So this resulted in a very effective solution that is used quite a bit even today, which is to have an real-time information about whether somebody is in CODIS or not. And this was what is called like a DNA checkbox that's presented. That's the OLEG is the Ohio Law Enforcement Gateway. That's a statewide database for that. So when anybody who is in law enforcement can look somebody up, there is a little red checkbox right above their picture and their name, indicating whether they are in CODIS or not. So that was one of the things that changed as a result of these identified misses. There was also, when there were failed samples, those notifications weren't really sent to a centralized location, and so that changed as a result. And there was a private lab where some of the samples were being sent, and as follow-up, which again is not necessarily cause and effect here, but as a result, all swabs started to be tested by the state crime lab instead of a private lab. Anthony Sowell and Larry McGowan are just two of the several high-profile misses that we had known about in Cuyahoga County prior to applying for this money in 2016. We were the first SACI grantee for ODNA, Lawfully ODNA. And one of the main reasons that we applied for it was that we knew that there were these high-profile misses. We had already started testing and working through these never-tested kits that were primarily from Cleveland Police Department. And Cleveland Police Department had a policy at the time to not necessarily force a swab, which is not necessarily in compliance with state law. So we knew that Cleveland had misses. We knew the prison system had misses. The Cuyahoga County Prosecutor's Office had prosecuted some of these misses once they were identified, which really emphasized the point that, like, you could test all these kits, but if the perpetrator is not in CODIS, then that evidence won't produce a hit to a known offender. And we know the strong probative value of getting a DNA hit in many of these cases, especially when the suspect is not named. So it suggested that we did have a problem in Cuyahoga County with collecting DNA, and it was likely widespread, but we really didn't know the extent of it prior to getting this grant. Once we got the first grant, though, we started to address this. And the first thing we had to do for this was working within the Ohio DNA collection statute, which Shannon's going to talk about.
That's correct, Rachel. And what we did was we dissected Ohio Revised Code 2901.07, which is the Ohio DNA collection statute. This became effective July 1st of 2011, and is commonly referred to as a swab upon felony arrest state. And we are one of 19 states in our country that now permits not only convicted offenders, but those arrested for felonies. Also some outlier misdemeanors, including domestic violence or other crimes that may involve children, that permits misdemeanors and felonies, swabbing of offenders upon arrest, not just conviction, which is a significant change, and it significantly broadens the brush or the scope of who can be collected in our state. So now, upon a felony arrest, local law enforcement agencies are able to swab those that they're arresting, be it theft, receiving stolen property, murder. You know, it could be something as simple or trivial as a felony 5 theft or a felony 5 drug possession. You can be swabbed. But what we've noticed is that there are times when people are arrested and they're not swabbed. Everyone is only human, and people do slide through the cracks. So the beauty of this statute is that we now have the broad discretion to continue to swab these folks as they're in the pretrial process with us, which puts a lot of responsibility on our prosecutor's office. And we monitor these folks, and we try to make sure that if they're missed at arrest or arraignment, that we are then having our folks who have their boots on the ground, our floor prosecutors, having these folks swabbed, filing a motion, having a judge order it, and having our county sheriff's department swab them while they're either in our county jail or when they come to the pretrial process from the community. We're also finding, though, that we as prosecutors are also human, and sometimes that gets missed. So we still have the ability under the statute to swab folks if they're placed on a community control sanction, which is commonly known as probation. So if we miss them at their plea or their sentence, we can follow them, and we can talk with our probation department, and we can still have our sheriff's folks swab them while under supervision. When we start to lose them, and the power of our statute is that they're no longer under our supervision, no longer under community control, we cannot compel them to be swabbed. The beauty and the broad nature of the statute, is from start to finish, and it gives us a lot of time to figure out where we've missed and try to pick up the pieces and put it together. A lot of states don't allow for the ability to collect across the entire criminal justice system, so we are fortunate to have that. It's unique to be able to collect DNA at multiple points. But what is necessary to mention here is that where you have the most ability to collect and where it is the most important to focus is upon arrest. It's any felony arrest. As we all know, as we work through the system, as we look at our evidence, as we figure out what our case is, some lower level felonies may result in a plea to a misdemeanor. And if it's not one of those special misdemeanors that permits the swabbing, we lose that authority to compel someone to submit a swab, upon a plea to maybe a misdemeanor theft instead of a felony theft. So we always want to keep our eye at the beginning of this process, at the arrest, the pretrial phase, because upon conviction, things change.
So now that we've talked a little bit about the overall process, the misses, what were identified as some of the problems, as well as what the statute is in Ohio, which is very important when you talk about lawfully owed DNA, is that it all depends upon what the state allows for the collection. All states allow for and do mandate the DNA collection for a felony conviction, and that's kind of where things start to change across different kinds of states. What happens in terms of the legislation later around when DNA can be collected. So when we started this, the first part of being able to do lawfully owed DNA is really to get what BJA calls a census of everyone, which is basically a list of everyone that we could identify who lawfully owed DNA. This is a very complex way that we had to figure out how to do this. And I'll talk a little bit more about where you can get some more information about how we did this. But I will just start off by saying that this was a long process. It took about 2 years to be able to finally whittle this list down, to be able to identify those that could be confirmed to owe. And when we did, we found about 15,000 people confirmed to owe over about a 7-year period of time, which was much larger than what we had really anticipated. When we were writing the grant, we thought maybe a couple thousand we could identify. We really didn't know what that would look like. I think if you talk to other Lawfully owed DNA grants that have come since, their experience is very similar, and that the number that owe DNA is much larger than anticipated. That 15,000, though, over approximately 7 years, really only covers the two largest agencies, law enforcement agencies in the county, which would be the Cleveland Police Department and the Cuyahoga County Sheriff's Office. So this is still an underestimate, and it was those that were confirmed to owe, but still the issue, as we expected, was widespread, but it was actually much more widespread than we even anticipated it to be. So over the process of about 5 to 6 years, we've been working, now that we figured out that 15,000 people owe, actually the number whittled down to, because of duplicates, 4,931 individuals. And so we've been working for many years now to try to track these individuals down in the system and see if they pick up new offenses. Because as Shannon mentioned before, in Ohio, once someone is no longer under supervision, you can't compel them to get a swab. So they have to come back into the system to be able to collect that swab. And so we've been able to track these individuals through the system. We have now confirmed that 21% of these individuals now have DNA in CODIS, which is more than we anticipated, but still leaves about 4/5 of them not being able to get into to still owing DNA. From those that do now have their DNA in CODIS, we've received 116 forensic hits. And so for those of you who know about the size of the forensic index, it is much smaller in CODIS than the offender side of CODIS. So 4% is actually much larger than we also anticipated it to be. 64% of those were cold hits, meaning there wasn't a suspect in the crime. Those 116 hit to 11 different types of crime types, homicide, burglary, and the most of is sexual assault kits, which is not surprising given the testing in the county around so many different kits. Of those that have now, those 116 hits have been looked at again, and as a result, 23% of those have now been prosecuted as a result of obtaining those hits, and those individuals now being in CODIS. This is talking so far about what we have been doing to address some of the issues around ensuring those individuals are in CODIS and investigating the hits that result from this. But we also got a 19 grant to continue to address the issues and to shore up some of the problems that the first grant identified with collecting that. And so now we haven't presented this data before, so it's kind of exciting to be able to show kind of the follow-up to this. So we identified 15,000 individuals. We've been trying to fix some of the issues in Cuyahoga County around lawfully owed DNA. And so here's some of the results of some of the work that's been done and the successes that we've been able to do around solving violent crimes. Here are some individuals that Shannon's going to talk about that were successfully prosecuted as a result.
Thank you, Rachel. I'll begin with somebody who we know as Antonio Huffman. But however, at the time of the sexual assault in 1997, a victim knew her assailant as Tony. She was 17 years old at the time. The victim did go to a hospital and have a sexual assault kit collected. In 1997, however, that kit was not tested. Fast forward to 2012, Antonio Huffman is arrested and he's charged with felonious assault. During that process, he is not swabbed. 3 years go by, and in 2015, Antonio Huffman is arrested again. This time he's charged with illegally possessing a firearm. He is not swabbed upon his arrest. He's not swabbed during the pendency of that case. And it appears that he is pled and sentenced and receives community control. And it isn't until he's on community control with our broad statute, he is swabbed while on probation in 2015. So I think, as we all know from this presentation, he could have been collected as early as 2012. Nevertheless, it did catch up with him. He's collected in 2015. At that time, our sexual assault kit task force has been formed, and we have looked at the sexual assault of the 17-year-old victim. We had the kit tested. The lab did tell us that they were able to find an unknown male DNA profile in the kit. And without any further leads to identify this person in the sexual assault kit task force, we proceeded to the grand jury to indict a John Doe profile. And at that point, we were on John Doe 124. So that profile was indicted, and it sat for a short time until Antonio Huffman was swabbed, and he was entered into the CODIS database and subsequently hit to our 17-year-old's 1997 sexual assault kit. And then we ultimately amended that John Doe 124 to reflect Antonio Huffman. So this is a direct result of having somebody who owed DNA, who was on our census, being swabbed, hitting to a kit, and resulting in a prosecution. Another example from our county is Marquise Miller. This is a circumstance where a 14-year-old young woman was raped by an unknown male, no suspect. She did have a sexual assault kit collected. Unlike the former case, this kit was tested at the time in 2012, but it did not produce a hit. But a profile was entered into CODIS. In 2014, who we now know as Marquise Miller, was prosecuted, pled guilty to a felony theft offense. While his DNA should have been collected throughout that process, either arrest, arraignment, pretrial, plea, sentence, or probation, it was not collected. So he was put on our owed DNA census. So we began to watch him. In 2017, while he was still on probation, Miller was then swabbed at the request of the Cuyahoga County Prosecutor's Office and our sexual assault kit task force while he was involved with the probation department. His swab subsequently produces a CODIS hit to our 14-year-old female victim sexual assault kit that was entered in 2012. The case was investigated in our task force, and in 2019, Marquise Miller was indicted for the rape of this 14-year-old young woman. He did plead guilty and received an 8-year prison term. And this is a direct result of the Owed DNA initiative. I will say we aren't seeing that so much anymore. We're playing less of catch up. We think that we, through the establishment of our task force here and investigating the hits when they come around contemporaneously, now that we have a better eye on them, we're playing less of a catch-up game. So it really does speak to the success of the project.
So here are some of the stats that I talked about, not presenting before because we're finalizing them now, about what does the swabbing look like now. I'll give the stats a little bit to not lead you in suspense anymore, but I want to talk a little bit about, as well as what we think is one of the main drivers of not missing people anymore in Cuyahoga County and what has been very successful in that, and how the Cuyahoga County Prosecutor's Office has led this effort. So as part of the 19 Sexual Assault Kit Initiative ODNA grant, we have been monitoring and implementing policies to help address some of this, identify any outstanding issues that we still have, in particular for arrests, still seems to be one of the issues, and continuing to raise awareness about the importance of lawfully ODNA in our jurisdiction and beyond. So as a direct result of the ODNA initiative, the Cuyahoga County Prosecutor's Office realized that while these individuals were under the purview of prosecution in the courts, it was a great opportunity after arrest and then they're being indicted or arraigned of those charges. That is a perfect opportunity and actually is incorporated into the legislation that the courts shall ensure that the DNA is collected. So the prosecutor's office developed a policy around ensuring that prosecutors monitor the suspects, the defendants on their dockets, and make sure that they are swabbed before a case is pled or sentenced. And so Shannon can talk more about that because she's the one sort of leading those efforts. But we think that that is one of the main drivers that has led to some of these really effective follow-up efforts. So what we recently have done is we took a list of every single individual who's on probation in Cuyahoga County at one point in time, which was around 7,000 individuals. And then we gave that information to the State Crime Lab, Ohio Bureau of Criminal Investigations, and asked them to provide information about whether those probationers were in CODIS. And here you can see that at a point in time, 95% of all the probationers were in CODIS, which is much improved compared to the number that we saw when we first started this initiative, where we had a very large number of people from our census. Out of about 15,000 individuals, we got about 500 and so individuals on probation who had not been swabbed. So this is certainly an improvement over the last several years. We looked up the status of the 355 individuals, or the 5% who were not in CODIS. And we found that, so the idea of taking a probationer is that, the rationale for that is that by the time they reach probation, all of them really should have been swabbed because they're reaching the end of their criminal justice process. So we followed up with the 355 individuals, and we found that 62% of those had been arrested and arraigned. So they had two different steps in that process, which means they were missed twice as part of that. When we ended up following up in subsequent ones, over half of these 355 individuals ended up getting into CODIS. So that 355 even shrunk down later on. When we did a snapshot, they weren't in there, but when we followed up further times, those individuals did end up making it to CODIS, which means they were swabbed at a subsequent time. But of those, and we looked at for the reasons and followed them in the process to see why they were missed. Some of the probationers were not really a traditional probationer. They were really under a court supervised release as part of a bail condition. So they really hadn't gone much through the criminal justice process at that point. They weren't at the end like we sort of anticipated. Some of the individuals were missed because the charges were either dismissed or they pled quickly to the case before ensuring that they were swabbed before they could do that. The issue here is that once those individuals, the cases were dismissed or pled, Ohio lost the ability to compel them to provide a swab. We also found that not all individuals were arrested or arraigned, which presents problems for the system. If you have steps, step A, step B, step C, the system really assumes that everyone follows step A, step B, and step C. But some individuals don't follow that process. They aren't arrested on site and instead are, the first time they come into contact with law enforcement and get the ability to be swabbed is at arraignment. Some of those were arrested and then not arraigned of the charges. So that's also the ability to miss there. But the system really needs to be able to track them over time and to follow up and have information on step A, step B, step C to ensure that people aren't missed. And then some of the individuals just went capious. And so they were missed they weren't arrested and then never showed up for their arraignment. And so there was no opportunity to swab them. But again, much greater success and much smaller numbers than what was originally done when we first started this project in 2016. So we're going to briefly provide some recommendations and lessons learned in this process for other jurisdictions. One thing that we identified, as I kind of alluded to earlier, is that swab a felony arrest is more complicated than it sounds. Not all individuals know whether it's a felony at the time of arrest. are those pills Advil or aspirin, or are those some type of controlled substance that they're not legally allowed to have? So sometimes the felony distinction, depending upon their prior criminal history and other things, is not particularly clear. And again, the criminal justice system is a system that requires collaboration across the different entities as it moves from police to prosecutors to the courts to probation or to prison and then back to probation. So the prosecutors in implementing the swabbing policy and the court system really were effective at being able to catch the swabs that weren't done at arrest as a sort of check of step A because they're step B. And then states, unfortunately, though, vary dramatically in who can be swabbed and when they can be swabbed in the process. So this becomes even more complicated depending upon the different state statutes that allow for that. Since Ohio does allow at multiple time points, it is good, but it also means that it requires more collaboration and coordination across the agencies.
So we would recommend that you have a passive way to collect DNA, akin to a watch list of individuals who owe. This is a way for your prosecutor's office to keep an eye on folks who are traveling through the criminal justice system. And once again, this is a result of that broad 2011 DNA collection statute. So in particular in Cuyahoga County, our prosecutor's office worked extensively with our state crime lab, the Bureau of Criminal Investigation, and we get regular updates of folks who are entering the CODIS database. We have in our Justice Matters case management software system party cards for all of our defendants. And the party cards contain lots of information, including contact, personal identifiers, a notes section, other pending cases. It's a wealth of knowledge, but what it does include is a tab for whether a person's data and DNA has been entered into CODIS, and it's a running timeline, and it gets updated when we get our data from the Bureau of Criminal Investigation. And for example, it might say today, March 9th, 2023, John Smith's DNA is still owing. However, if John Smith was in the process and had been collected, the next update in 3 months might say John Smith DNA now in the CODIS database. This helps our floor prosecutors, the folks who are prosecuting the bulk of our cases, have an easy tool to go to quickly to see if their offender still owes DNA. We do have a policy that says that you should not plead a case, you should not sentence a case if a person still owes. Obviously, some fall through the cracks, or some are just so urgent that has to be, maybe overlooked in the moment. But that party card is meant to be a tool to help our prosecutors monitor this and hopefully not miss those folks who still owe. It allows our prosecutors and our court to get involved early and catch those who weren't swabbed either at arrest or arraignment and get them during the pretrial, plea, or sentence phase. If any of you have any questions about this policy, we have shared it in the past. So my contact information, I believe, was at the beginning and will be again at the end of this presentation. And you are welcome to reach out, and I'll be happy to share that with you.
So as part of this, the prosecutors get this flag that notifies them if someone on their docket, one of the defendants on their docket, owes DNA, which is an effective way because we know that the more robust the DNA system is, the more return on investment you get for testing all the forensic samples that go into this. And so I think really the foresight and ability for SAGI to see that, you can test all these kids, but if there's nothing that it's going to hit to in that database, you sort of lose the value or don't get as much from the value of testing the kits because it's not hitting to anything. And we know, especially when there's not a named suspect, this evidence have a strong probative value for prosecuting these cases. And so the more return on investment, swabs don't actually take that much money. They're relatively low cost ability to solve these things. So you're spending all this money on testing and forensic samples, then you get more for your buck if you're actually ensuring that all those that should be in there are in there. As part of this, we also had early conversations to identify some of the issues of why there were 15,000 individuals who had missed. And we found that that there needed to be more and frequent training of frontline individuals in the prison systems, in the county system, and the jail systems, as well as prosecutors to really emphasize the importance of ensuring DNA is collected. And, over time, some of the individuals, there wasn't as much training around how to do a better buccal swab and things like that. So BCI provided more training, but also was able to provide reports to different jurisdictions and say, hey, you should really take a look at this because according to our records, this person likely owes DNA. Can you kind of see what was going on? And so they were able to identify potential issues with certain individuals not collecting or other issues. So the sheriff's office was able to identify some of those issues from that information. So that training provided a really important toolkit for ensuring compliance.
And number 5, this kind of goes in conjunction with number 2. This is where we're asking you to work closely with your state agency that maintains your CODIS database to help you get those regular updates on who owes their DNA and to ensure that you and your local law enforcement and prosecutors can get that DNA collected. What we do is we get quarterly updates from our crime lab. We take our roster of folks in Justice Matters, our case management software, the whole roster. We send it to our Bureau of Crime Investigation. They review that list against their data, and they tell us if any of those folks are in CODIS. That list is returned to us. We update our party cards, which is how our boots on the ground prosecutors know who owes. We update those party cards to reflect whether they are in or out. And then that's what helps us to collect those folks who we know still aren't in. There are people who sometimes were in and are now out. Maybe they've been expunged. They're no longer a suspect in a case, or their DNA profile no longer meets the scientific standards for entry. And we use that data to update our system. So maybe someone who was in is now out, and we then try to collect them again.
So as a final sort of call to action, here's all this information we provided. I'd like to sort of challenge you to think about what can you do, depending upon where you sit in your job, to make improvements or to see whether your jurisdiction is missing samples. Most jurisdictions who asked that question did identify more, again, than they thought that they would. So to help you with sort of doing that, here's some more information that my team and I have published around this. Here's a research brief and a way to find it. Here, research brief is it's a less jargony sort of report talking step by step about how we went about figuring out who owed DNA in accordance with the Ohio statute around DNA collection. And then we detailed this as well as the outcomes in I recently published this article in the Journal of Forensic Sciences, detailing all the things that we had here with much more information. If you're interested in following up, that article is open source, so it's not behind a paywall, so you should be able to get it. If you're unable to get this article, feel free to email me and I'd be happy to provide it to you. Here's our contact information. If you are interested in getting any more information about some of the things we talked about, the article, or as Shannon mentioned, we're also happy to provide recommendations for how to get started for this if you're interested in addressing this in your jurisdiction.
Hi, everyone. I'm Michaela Ascalise, a forensic scientist at RTI International, and I'll be your moderator today. Thank you so much, Rachel and Shannon, for being here with us. We have quite a few questions, so we're going to go ahead and jump in. All right. So the first question from an audience member We're going to direct this to Shannon. Reads, I have a question about indicting a suspect based on a DNA profile. Does this help extend the statute of limitations, if there is one, for sexual assault?
That's a great question. In Ohio, we do have statute of limitations for sexual assault. It's currently 25 years. And we do indict DNA profiles. And I don't know if I would say it extends it, but what you're doing is securing it. So if you get that indictment during that 25-year time, regardless of when we are able to develop the true identity of that person, you've secured your indictment within that time frame. So there is value in doing that. I'm actually going into our grand jury tomorrow for our John Doe 188. So, we're always obviously still striving to identify that, that person, but we do secure that indictment to guarantee that we're within our statute of limitations.
That's great. Thank you for clarifying that. All right. And then another question for you, Shannon. Do you have unsupervised probation in your state? If so, how do you handle these collections when the individual is no longer on probation once they leave court at conclusion of their case?
So unsupervised probation, I would imagine for us here in Cuyahoga County would be akin to like an inactive probation. Some folks are found to be good candidates for that. Sometimes once they've gone through the more intensive probation services, and if they're in compliance, they can be on an inactive, but they are still then within our jurisdiction. Once they leave probation, we've lost the teeth. We don't have the ability to compel them. I have attended other seminars where I know other states have the ability to send letters to folks to invite them to come to maybe a local law enforcement agency to, of their own volition, give a swab. We haven't completely explored that yet here. Rachel may be able to speak more about that. We're not doing that yet. I don't know if our statute gives us that permission. And I think Rachel knows a little bit more if you want to tag team this, Rachel.
Yeah, I'll disclose that I'm a researcher and not I don't have a law degree, but from my understanding, that Ohio, that the interpretation of the Ohio statute says that you can't really send letters and ask people to come in to do that, that there isn't really the judicial authority to be able to compel individuals who are not under supervision of the criminal justice system to be able to provide that swab. So they truly are sort of lost unless they come back into the system or become a suspect in another crime.
All right, thank you for answering that. All right, I think I'm going to punt this next question to you, Rachel. How did you handle testing of all these samples at the lab so that they were tested and entered into CODIS in a timely fashion? Are you required to expunge the arrestee sample? If so, how did this factor into the testing process?
So in terms of ensuring that they were all sort of handle the testing of all of those, the state crime lab in Ohio is the one that tests all of those, BCI, the Bureau of Criminal Investigations. And so really, instead of us going out and like trying to find these individuals, since we couldn't compel them to give swabs, we were instead working within the system to be able to capture information about our census members to ensure that they were swabbed. So really, it wasn't about having a backlog of like swabs to test so much as having the crime lab having the capacity to test those in an efficient manner, because these were people who primarily picked up new charges or were swabbed upon the request of the prosecutor's office. And so it was sort of like basically business as usual for the entities who are already charged with collecting those swabs and are testing the swabs. So it didn't really produce as much of a backlog as that, since we weren't able to really like pool 3,000 people and have them at one time, but instead sort of watched as they were swabbed, or what happens when we confirmed that they were swabbed. And then can you repeat to me the second part of the question?
Yeah, of course. The second part was just asking, are you required to expunge the arrestee sample? And then if so, how did that factor into the process?
In Ohio, an individual can have their DNA removed from CODIS, or I guess more accurately, the state system. But they have to, upon expungement or a not guilty, but they have to petition the court to have that removed. There are instances as well as and BCI would be able to explain all the nuance of that, but there are instances where someone's DNA needs to be removed, or for a variety of reasons, not just upon a not guilty or expungement, but for several reasons, people's DNA can come in and out of CODIS. And as we are tracking these individuals over time, our census members, we do see that for a very small portion, their DNA does actually come in and out. So one quarter, they may have their DNA in CODIS, and then the next quarter, their DNA may not be in CODIS. So that is a sort of expected outcome of this. Because for a variety of reasons, as you mentioned, people can come in and out. But in Ohio, people have to petition to have their DNA removed upon expungement or not guilty.
No, that's a great point.
Automatic.
I didn't know that.
Mm-hmm.
All right. So another kind of follow-up question. Either of you can take this, but if DNA is taken at the point of arrest, what happens to the swab if the arrestee is found not guilty of the crime?
Yeah, so they could petition to have their DNA removed.
Okay.
And I think that probably happens. I know it happens, and I think, perhaps there's differences across the state into which people might be aware of that. So I know in some instances in the bigger counties, it's sort of standard among defense attorneys and other, like, they know that, and they have the sort of ability to, file that paperwork or be able to create that instance if somebody is found not guilty.
Okay, great. And then again, a question for either of you, but have you experienced any pushback or challenges from the community regarding pursuit of these owed DNA samples?
I don't know if Rachel, you want to take it. I don't have anything to speak to that. I haven't heard or been, made privy to any negative feelings from the community about the pursuit of these swabs. I think so much good has come from, being more vigilant about collecting these swabs, that if anything, I think there's been positive for us. But I would also defer to Rachel on that.
Yeah, I think there was about the publication we mentioned, there was an article in the Plain Dealer, Cleveland.com about that, about just the general approach. And actually the title was like something catchy, like how not to catch a rapist. And it's by not swabbing for DNA when they're supposed to. So I think it's a pretty standardized within the system. I think public awareness around the issue is important. But there hasn't been any. And in fact, like Shannon said, I think if nothing else, it's more dismay that all these individuals who should have been in CODIS, but were not, and therefore their victims didn't get justice, that they continue to commit crimes, those sorts of things, as a low cost, sort of low stakes way to be able to solve unsolved crimes, or at least have leads for unsolved crimes. And I think in terms of, seeing DNA as, I think it's been upheld pretty substantially across the Supreme Court and other jurisdictions of the legality of being able to collect DNA. States differ drastically in when they can collect DNA, but DNA from arrestees has also been found to be, solidly a legal tactic, and there hasn't been much pushback that I've seen.
Now, we talked about pushback from the community, but how about Shannon, for example? How do you handle collections if the individual refuses to have their sample collected?
Folks can use force if necessary, and we don't like to get to that point. And I think generally we don't have to. My experience, I've observed some of the swabbing procedures in our arraignment room, where we're collecting folks who were screening as they're coming in to see if they owe, of one of our proactive measures. And just, I've observed it only once, so I can't tell you what happens daily, but in speaking with the sheriff's department who does those collections, there was no discussion of experiencing any trouble getting those collected. I mean, especially when they're in the arraignment room, a judge is telling them that you are required by law to provide the swab. And I don't know if that extra layer, having it come from the bench, just gives people more confidence that it's lawful. But we are permitted to use force if necessary. I don't know of any circumstance where we've had to.
Okay, thank you for answering that.
I have heard law enforcement sort of say that to some extent, like those kinds of things, inevitably it's going to happen. So sometimes just giving individuals waiting time, you'd be like, well, like, we don't necessarily have to we don't want to use force. We're just going to let you sit there in jail, which you're already there because of a case. And so it's like, you're not going anywhere and we're going to collect it. And I think I have heard law enforcement say, like, the more they protest, the more they come to our attention of like, wonder why they're protesting so hard to get their DNA collected. Maybe this is someone we really should be paying attention to. So I think if anything, it can sometimes backfire if individuals refuse to. But yeah, state law says that they can do it by force, but I have heard of them just waiting out until the person is like, well, you will, and they do. As far as from what I've heard, there's not an issue with that.
Yeah, and then there also becomes another layer of once you get through your arraignment, you get your counsel or you've hired someone, and generally the defense attorneys understand the law and they're able to speak with their client in such a way to get it done amicably.
Okay, great. All right, this next question's for Rachel. Can you explain a bit more about what you mean by expired scientific way of keeping the DNA data?
I'm trying to remember in what context I said that.
We can always come back to that.
Okay,
I'm not sure if that one can be clarified a bit more.
Yeah. Maybe just a little bit more context under which I said that. I have to admit, I didn't listen to my own voice because it's very difficult to listen to yourself or your own recording. So while I did give it, I didn't listen to it because it is still a little jarring on the ears.
All right.
So if you can prompt me.
Well, the next question's for Shannon then. When a subject has an active warrant, do you indicate in the warrant that they should be tested upon arrest?
I don't believe that our warrant says they owe, but I don't believe a warrant has an indicator for that. But it's just, the policy that, say, for example, you pick that person up for the warrant. When you run them through our Ohio law enforcement gateway, like Rachel talked about in the presentation, you'll see that they owe. So they should just be automatically being swabbed. Although I will say, because of our census that we've created and the folks we know who owe, we do have an investigator who exclusively works on this project. Well, not exclusively, but a lot. And he is going through the list and looking for people with active warrants. So while I don't believe the actual warrant document that our sheriff's department has includes that information, when we see folks who have an active warrant, we are notifying our warrant unit, look, not only does John Doe need to be picked up because he has a drug case and he didn't come to his arraignment, but hey, guess what? He also owes DNA. So maybe they're very overworked, but if you get a down moment, this would be somebody that we would encourage you to go after, even though it seems like a low-level criminal offense. It's a double whammy. We kill two birds with one stone, for lack of a better term. So we are watching those folks, but other than us putting the bug in the sheriff's department ear, I don't believe there's any way for them to know that.
I see. And now, Shannon, if a person was missed during a felony arrest, can you collect on a future misdemeanor, or do they absolutely need a new felony charge?
You need to be arrested for another felony. We can't go back for, if you were arrested on the felony, your case went through the system, you pled, you're off probation, clock starts all over with the new case, can't rely on that old one. So the misdemeanor arrest, if it was for like a crime against a child or sexual in nature, we would be able to swab you, but otherwise we don't have the teeth there in our statute.
Okay. No, that makes sense. All right, and then this next question is for you, Rachel. Can you explain a bit more about what you, do you think that rapid DNA would assist in the future?
Yes. So I will also disclose that I am not a forensic scientist. I'm a criminologist, but I've learned more about DNA than I ever thought that I would in my life. So that's a positive thing. So for all of you forensic scientists out there, from my understanding of the way that it works, as well as probably more importantly than the technology, or as important is the implementation of how it works within state laws. I think that rapid DNA actually has the potential to drastically change the face of this missed collection. And the reason for that is, assuming that they are collecting it again at the first time in which they have the ability to collect it, which is a felony arrest. And they understand that it's which cases are felonies and some of the early things that we talked about. I think if you can get information back fairly quickly, it would help with, sort of speed up the process to be able to connect to crimes. And so that person may, who may swab and hit within a couple hours, or potentially hit to a couple hours within the forensic index of CODIS, that information would be extremely useful for a prosecution, even if it's on an unrelated charge. But that's certainly something law enforcement wants to know before they adjudicate one case is, are they connected to a series of other cases or another case? Now, it doesn't necessarily mean that they're going to go straight to jail for that. It's still just a lead that has to be investigated, but that lead comes much faster. The second thing is that I think it has the potential to really prevent this sort of handing off of the system, so that, as I think we mentioned in the thing, like in Ohio, several entities can actually swab, but all the entities kind of have to be working together and ensuring that DNA is collected. So police at arrests, prosecutors once that individual is indicted, courts once that person is in pretrial or in disposition, and then the probation and then parole. All those entities kind of need to stay engaged and have information from the crime lab in real time. And that rapid DNA has the ability to provide that information, almost immediately to any of the entities. So you don't have to hand off. You can just have one entity that does that and would know that information and have that information readily available. Now, I think the implementation part of that is still going to matter, and making sure that people know that it's there and using it as it's supposed to be done. But I think that that technology really does have the potential to ensure that, everyone is swabbed that should be, or most people are swabbed that should be. And from some of the stats that I've seen, and estimates of the number of missed individuals in CODIS, it's upwards of 1 million people who should be in CODIS and are not because of this issue. So I think any work that we could do to address that would make a substantial dent in ensuring that everyone who owes is in there.
No, for sure. All right, we're kind of coming to the end of our segment. I think we're gonna let me squeeze one more question in here. If anyone else didn't get their question answered today, please feel free to reach out to Rachel and Shannon. But the last question, I think it's going to be directed for you, Shannon, but Wisconsin can charge individuals with a misdemeanor for failure to provide when they lawfully owe DNA. Does your state have similar prosecuting power?
Not to my knowledge, because I think we'd be all over that, and we haven't done anything in that way. That's a nicely written statute, and that really helps you guys out. We don't have that ability here.
Okay. All right, great. Did you have any final thoughts to share with the audience and everyone today?
I would say, to piggyback off Shannon's, I think one of the larger takeaways and some of the work that we're doing with her office and extending out is working from other states about lessons learned in writing those statutes. And, sometimes statutes are written with an idea in mind, but not necessarily how it really works in practice. And so having something like this in Wisconsin, where you can collect on something like that, Florida has a statute that allows for, for a prosecutor to be able to come back and compel them to provide a swab. Those kinds of things, I think we can learn a lot from other states about how to better and effectively close the loopholes in the missed DNA collection. So I think there still needs to be more work around lessons learned from other states, because it really, it's a federal system. So all states are relying on all other states to do their job. And sort of all in this together. So learning from other states is also important to ensure we have consistency across states as well.
Great. Well, thank you so much again for being here with us today. And I think that wraps up today's segment.
Thank you all.
Thank you.
Before you leave today's webinar, I'd like to draw your attention to our feedback form. It takes less than 5 minutes to complete and can be accessed via the checkbox icon directly above the chat. Your honest feedback is invaluable as we continually search for ways to improve and provide the best experience possible. Lastly, across the top of the live stream window are links to our social media profiles, including Twitter, LinkedIn, and Facebook. There is also a link to the FTCOE website, the Just Science podcast, and the FTCOE newsletter registration. Like, follow, or subscribe to stay up to date with everything the FTCOE is doing in support of the forensic community. Thank you again for attending, and we hope everyone has a great day.